Hello, boys and girls. Welcome to another scintillating, didactic, and provocative session today. Today we are looking at real property and landlord-tenant law. Important subjects as components of commercial law. So let's begin. So we're going to be looking at different types of real property and something you may not have heard before. Again, the terms, as we've discussed with our friend Voltaire, before you address me, define your terms. One of the legal terms we're going to be looking at today, which may be new to you, is future interests. And I'm going to talk about how ownership interests in land get transferred. We're going to talk about non-possessory interests in land. I'm going to talk about various types of landlord tenancy, and I bet you may be surprised to learn a little bit about landlord-tenant leases. And then we're going to talk about, of course, the all-important landlord and tenant rights that, according to South Dakota state statute, and virtually every other state in the union has a statute involving landlord-tenant rights. So let's begin with some more definitions to keep our friend Mr. Voltaire happy. So what is real property as distinguished from personal property? Well, real property is real estate, right? Land involves land. Whereas personal property is virtually everything else other than land. Personal property doesn't include real property. Which brings us to ask, what are fixtures? Fixtures are, in fact, personal property that may be attached to real estate and also mineral and air rights, as well as surface property, such as trees and things of that nature. So let's take, for example, a classroom. And most classrooms today have an overhead projector, right? That is affixed to the ceiling. And what is important to know about fixtures, as in this case, a projector that is affixed to a ceiling, is that once this personal property, the projector, is affixed to real property, the building, okay, which is attached to the land, it becomes real property. Let me give you that again. Fixtures become real property once they are affixed to real estate. So the classic cases I've just illustrated for you is a projector which is affixed to the ceiling, which is part of the building, which is affixed to the land. And all of it is transformed from being personal property into being real property. Now, can it be returned from real property to personal property? Can the process be reversed? Sure. When you detach the projector, it now becomes personal property again. And so, yes, buildings, once they are built upon real estate, become real property. All right. So when you buy real property, besides buying the land, you're buying, what is affixed to it. Okay. Which brings us to ask, well, what about air rights to include sunlight? Well, the normal rule is that property owners own not only the surface property, but they own all the property, all of the property that would be above them and below them to the core of the earth. Okay? Going up and going down involves real property rights. Now, we all know, of course, that the Federal Aeronautics Administration authorizes plane flights, what we would call easements. That is, there are lawful entrances that third parties may take advantage of involving overflying. Mineral rights, certainly going down to the center of the earth, also include what we simply refer to as subjacent and adjacent support. Let me illustrate what we're talking about here. Now, by having subjacent support rights, we're saying that, let's say, a neighbor who has property could not drill underneath his property into your property, creating obviously support problems for your property and maybe even your house. Adjacent support, same situation. Your neighbor would not be able to dig or excavate his own property if it would have an adjacent impact, negative in nature, to yours. So certainly if your neighbor starts digging by your fence line and digging deep, there may come a point where the sub-adjacent and the adjacent support, collapses. And clearly, it's important to understand that your rights end where another person's begins, and their rights end where your rights begin. So you do not have a legal right to interfere with the adjacent and subjacent support of neighbors' property. And I think that's probably pretty obvious. You just have to think about it. Ownership rights in land is called at law an estate. An estate. So yes, you own a home. That is legally referred to as an estate. Now, a freehold, we're going to talk about different types of property, okay? Different types of estates. The highest form, the most valuable form of an estate is simply referred to, this is an Old English legal term, as a fee simple estate. This is the highest form where the owner possesses a complete bundle of rights, subjacent support, adjacent support, legal rights all the way up from the land, into the stratosphere. Now, let me distinguish a fee simple estate from a life estate. A life estate is clearly less in value than a fee simple estate. It's an interest in land that lasts for the life of a specified person, usually referred to as the grantee, and that upon the death of that specified person, the land either reverts to the original grantor or to a third party. Let me give you a classic illustration. It's not unusual for a married person, upon their death, in their will, to leave a life estate in their property, in their real estate, to their spouse. And that upon the death of the spouse, then the property will either revert to the grantor's estate, which probably, is set up a trust or maybe some type of a charitable use, or may be transferred to an identified third party. So, classic case would be a home in which a testator in their will leaves their interest in a life estate for the life of the spouse. Once the surviving spouse dies, then the property is transferred to the children in equal amounts. That would be a classic illustration of a life estate. A life estate can be terminated if some particular event occurs that doesn't violate public policy. Now, during the life estate, the person holding the life estate can mortgage the property, they can lease the property, or otherwise transfer the interest for the period of the life estate only. So, for example, a spouse may decide that she doesn't want to live on the property because she's moving into an elder care facility, and so she leases out the property for the duration of her life, a life estate situation. Now, it's important to understand that life estate holders um, cannot waste property, that is, destroy it. They have to maintain it in a similar situation in which they found it and possess it, and they have to pay the taxes on it. Yes, indeedy. So let's take a look at an actual case here called Freeman versus Bars. So we got Bars who paid $3.5 million to Freeman, and so what did Freeman do with the estate? So Bars paid $3.5 million to Freeman for 4,000 acres of land, including a covered pole barn, which had a large cattle scale. Now, ever seen a cattle scale? Well, I haven't seen one either. But the cattle scale also enclosed a veterinarian's office. Now, the parties' form contract stated that all fixtures were included in the sale. Now, while there was nothing in the contract that said anything about the sale of the cattle scale, the parties ultimately disagreed as to who actually owned the cattle scale. And of course, the question is, well, did this cattle scale become a fixture to the property once it was attached? Well, what's our rule of law here? Well, the rule is characterization of a fixture depends on the finding of three separate elements. First, was the cattle scale annexed to the realty, to the real property? Was it adapted to the use to which the real estate is normally devoted? And what was the intent of the annexor that the object become a permanent accession to the estate? In applying it to these facts, the scale was in fact designed to be portable, and 70% of the scales that were installed in the present manner were actually affixed to land. The present scale could be moved by cutting away a welded metal fence and lifting the scale with heavy machinery. Does that sound to you like a fixture or personal property? The scale has remained in place since it was originally installed. Now, the ranch manager for the plaintiff testified the scale was purchased to be stationary, whether it was portable or not. So in this case, the court found, looks like the scale is definitely affixed to the property, and the intent of the seller was that, it would remain affixed to the property, so it becomes real property, and so the scale goes with the sale of the real estate. Affirmed for the buyer. Okay, let's talk about future interests. A future interest is the legal right to possess property in the future. So let's take, for example, a person who wishes to transfer the property, real estate, to a young person, but doesn't want them to legally possess it until they reach the age of 25. Well, what's magical about 25? Well, nothing other than the grantor may decide that the party to whom he or she wishes to transfer the property, they want them to be more mature than they are. And so they set a time in the future when the property will be transferred. Well, until that time occurs, we have what is called a non-possessory interest. Is it possible for that person to sell their future interest in the property or lease it? Yes. Yes, they can. So what is a reversion right? A reversion right is the right to possess the return of a property to the grantor after there's been an expiration of the limitation. So property can revert upon a party getting married. And now, okay, the person who is granted the non-possessory interest as well, if the person gets married, well, I don't need to have the property anymore. And so it's going to revert to my estate. A remainder interest is the right to possession returning to a third party after, other than the grantor, after the limitation expiration. So let's assume for a moment we have a grantor who grants transfer of the property to another party upon their graduation from college. But if they don't graduate from college, then it returns to the grantor. Okay? So you can see how you can put these limitations into deeds of land before they are, transferred. There are also known as concurrent types of real estate ownership. The most popular one is called joint tenancy, which gives co-owners the right of survivorship upon the death of a joint tenant. So any property listed in joint tenancy is automatically, upon the death of one of the joint tenants, going to revert to the survivor. Even though the deceased joint tenant has left their interest to another party, that doesn't operate legally, because the legal status of joint tenancy gives the surviving tenant the right to take all of the property upon the death of a joint tenant. How do you create a joint tenancy? By using the names of both parties and the term joint tenants after their names in the deed, so it's clear that it is. Now, it is true that a joint tenant may partition, that is, transfer his or her interest without the consent of the other joint tenant, but obviously it has to happen while they're alive. And when they do that, when they transfer their interest without the consent of the other joint tenant, that terminates the joint tenancy. A second type of tenancy is referred to as tenancy in common. This is where we have co-ownership of the property, the real estate, but upon the death of a co-owner, the rights of the decedent pass to the decedent's heirs. You see the difference between tenancy in common and joint tenancy. So in a tenancy in common, how do we create that? Again, by listing both the names on the deed as co-owners or tenants in common, so it is clear what the intention is of the parties when they enter into it. A tenant in common can sell or otherwise transfer his or her interest without the consent of the co-owner. Okay, let me see here. We have one more status here. Let me make sure I get this right for you. Looks like we got it all taken care of. All right, let's move on to our illustrating case, which is Jackson versus the estate of Green. So we've got Green and Jackson that own this real estate as joint tenants. Now, Green has filed a petition in court, which they can do, to partition the land parcels, but he died before the court completed the action. As such, the lower courts found that the land reverted to Jackson, but not to Green's heirs. And the legal issue presented is, does filing for partition of a joint tenancy terminate survivorship rights? Well, what do you think? Well, the rule is until an order of partition's been entered, that is, issued by the court, the partition has not been compelled. That is, it hasn't taken place. And thus the joint tenancy has not been severed, which means, yep, since we don't have a termination of the joint tenancy in this case, the surviving joint tenant takes the property, regardless of what the deceased wanted to do. Another form of tenancy. This one is the tenancy by entirety. What is tenancy by entirety? Well, it's a form of co-ownership, and it can only be used by married parties. It can only be used by two spouses as tenants by the entirety. Now, what's the benefit of tenancy by entirety? Well, the surviving spouse gets 1/2 of the interest by right of survivorship. So, when one of the tenants dies, the surviving spouse takes 1/2 automatically by right of survivorship. Only 1/2 though. Neither spouse can sell or transfer their interest without the permission of the other. Okay? Lastly, we have community property. Now, community property only exists legally in 9 states and only applies to married couples. South Dakota is not a community property state. California, Washington, Oregon, Idaho, Florida, Texas, Arizona are among the 9 community property states. So what is community property? Simply means that upon the death of one of the parties, the surviving spouse automatically receives 1/2 of the property, regardless of who accumulated it, and the remaining half goes to the heirs or to whatever party is designated in the will. Okay? Now, let me talk about the exception moment. The exception involves separate property. What is separate property? Separate property is not community property. It is brought into the marriage and kept separate. So let's take, for example, a family farm. And so a husband and wife are living together, everything is fine, and the wife's parents pass away and leave the farm to her alone in her name. And she keeps the property separate in her own name. Even though it's California, a community property state, her spouse does not take any interest because it's not community property. It is separate property. And even though the community property spouse dies, unless there's something in the will from the deceased spouse leaving the separate property to her surviving spouse, unless that happens, then it's going to be given or transferred according to her will. Now, why is all this important? Any property that is accumulated during marriage automatically becomes community property regardless of who has earned it. Okay? So it used to be we had one working spouse and the other one was a stay-at-home spouse raising children and taking care of the family and all. Yet under community property, the surviving spouse, let's assume it was the non-working spouse who didn't actually bring in any of the property into the marriage, nevertheless, under community property laws in community property states, would automatically receive 1/2 of it. What are non-possessory interests? A very important legal point. It is the right to use but not possess the property. So let's take, for example, an easement. What is an easement? An easement is the right to use another person's property, but you may not possess it. So the classic case is a sidewalk, right? Is a sidewalk? A sidewalk may be originally uh, put on your property by the city or by a developer, but yet you, the owner of the property, are required to maintain the sidewalk, which includes replacing it when it breaks up or is damaged. And yet the public has the legal right to ease, that is, to use the easement, even if you don't want them to, because the easement is a non-possessory interest that is accorded to third parties. So certainly cable, utility lines, plumbing, things of that nature that cross your property in the form of easements are non-possessory interests. How about by implication? By implication, these are situations where land is subdivided, but one part, let me go back here, but one part, such as a common entranceway, a bridge, a road, provides a common way to get in and a way to get out. Okay? So let's take, for example, you own property, and there is a road that is on your property that provides access to a lake that the public enjoys. And so this is what we would simply refer to an easement by implication, and that there is a legal right for third parties to, by implication, in order to get to the lake, have a right to enter your private property and use that road. Easements by necessity is where property is landlocked, and getting in and getting out can only be obtained by crossing over another person's land. Now let me talk about prescription. Prescription is better known as adverse possession. What is adverse possession? Well, adverse possession is when you adversely take the property of another against their will. So let me give you some examples. There are some requirements here that have to be met in order to have a true adverse possession. So let me actually give you a personal experience. When I lived outside of Atlanta in a small town called Jonesboro in Georgia, I bought this land, and in buying it, I had it surveyed, and that's routine. That when you purchase real estate, you always have a surveyor come out and survey the property. So, and he's got stakes that he puts in the ground to show, where your property ends and other parties' property begin. Well, the surveyor finished his survey, and surveys cost several $100s. They're not cheap. And it showed that my property line ran right through the bedroom of my neighbor's home. Well, obviously, I was suspicious about this situation, so I asked the surveyor to do it again because I didn't think he had it right. So, sure enough, he redid the survey and repeated the same results, showing that my property line and all went right through my neighbor's house. Well, here I am just buying this house, and this clearly is not going to make me a good friend of my neighbor, but we have a little problem here. So, and I got in-ground sprinklers and all the rest of this, whatnot, as he did too. So I knocked on the door and introduced myself. Unfortunately, we were both Army alumni. And I shared with him my survey. And I said, look, I've had my surveyor do this twice. You may want to hire your own surveyor. And I recommend that because after you do that, then I think we ought to chat about the property line here. and what we're going to do about it. So sure enough, he hired his own surveyor, and his surveyor came up with the same results that my surveyor had. Oh my, the property line runs through, his house. So clearly when his house was built, it wasn't properly sited, and he had had a contractor do that, but he didn't have a good survey done at the time. I said, well, here's the situation here. Now, while I legally own property running through your bedroom, here's the fix. Here's the fix, because obviously he's in a state of shock. Said, look, there's this principle called the principle of adverse possession, that if you use my land, my property, my real estate in an open and notorious way that is actual and exclusive, continuous and peaceful, yet hostile and adverse to my ownership, after the state statutory period of time has expired, that property will automatically become yours. In other words, it will automatically be conveyed to the adverse possessor by operation of law. So I said, now, for me, and actually for South Dakota and Georgia, the time period that has to exist uninterrupted is called 20 years. 20 years. So if for 20 years my neighbor openly and notoriously used my property that obviously ran through his bedroom, actually and exclusively, continuously and peacefully, clearly hostile and adverse to my ownership, in 20 years, he can go get his deed redone. I would have to have my deed redone to reveal that he is now the adverse owner of the property in question. So fortunately, we have this period of called tacking. His house was built before mine, and 20 years had run, because by the time my house was built, that owner, who actually was a dentist, and myself, you put his time and my time together, 20 years had passed. And so I said, I think you've already accomplished adverse possession. So my advice to you is get yourself a real estate lawyer and go ahead and get a deed redrafted, and I'll get mine redrafted. I mean, I'll go along with all this. I want to make this clean, because when I want to sell the property, which I did 6 years later, I don't want to have any clouded title. I don't want any issues that obviously the survey has raised. So I asked him, is that okay? Does that sound fine with you? He was delighted. So we had the surveys redone and had a new deed drawn up, and I did too. And so he was happy. I was happy. But that's an example of adverse possession. Now, why is this important, and why am I bothering you with it? Because if you happen to have a neighbor who moves his fence onto your property, or uses your property exclusively in accordance with these 4 criteria, you could lose legal control of that property after 20 years. So if the neighbor, makes a mistake and moves his fence or his garage or his whatever onto your property, you need to tell him to, politely, nicely, legally get on his side of the fence, so you don't have an adverse possession situation. Okay? All right. We've got another case here, the Ray versus Beacon-Hudson Mountain case. So it's a little complicated, but essentially involves, in 1931, a fellow by the name of Rose purchased a cottage in the Adirondack Mountains. We all love cottages, right? So while agreeing to rent the land upon which the cottage stood, that was the arrangement they had, that, hey, they purchased a cottage while agreeing to rent the land. Now, Ray was obligated to pay the taxes, and when the tenancy ended, the landlord would buy the cottage back at fair market value. That was the contract agreement. In 1960, so we got, some years later, the landlord terminated the lease of everyone in town, so Ray and other residents packed up and left. But Ray never received a penny for the cottage, in violation of the contract, right? Mount Beacon Incline Land subsequently purchased all the rights to the now abandoned 156-acre resort. So there are obviously a lot of other cabins and places around there. Now, when Ray died in 1962, so we got 31 years later, right, from the contract, her son and daughter-in-law re-entered the cottage and began to use it 1 month per year every summer from 1963 to 1988. They paid the taxes on the property, they insured the property, they installed utilities, and posted a sign that said no trespassing. Okay? See where we're going here? Does this sound a little adverse to you? So in 1978, Beacon Hudson bought the resort in a tax foreclosure. In 1988, the Rays filed suit claiming title to the cottage by adverse possession. Hudson counterclaimed, the buyer, counterclaimed to eject them. The trial court ruled for the couple, but the appellate court reversed, holding that the Rays had been absent too often to achieve true adverse possession. So what's the issue? Of course, the issue is, did the Rays acquire title by adverse possession? What's our rule of law here? The requirement of continuous possession is satisfied when the adverse claimant's acts of possessing the property are consistent with the acts of possession that ordinary owners of like properties would undertake. Isn't that what happened here? The plaintiff's actual summertime use for a full month each season, coupled with their repeated acts of repelling trespassers, improving, posting, padlocking, and securing the property in their absences throughout the summer, demonstrated their continuous dominion and control, right? And so, yeah, the higher court agreed and reversed for plaintiff Rays. Okay? All right, let's talk about land use regulation. Land use regulation. So, for example, I live here in Vermilion on Augusta Drive, and I live on hole number 18 of the golf course. And there are restrictive covenants, if you will, requirements that are on the deeds to all property owners who are living on the golf course. And we have an 18-hole golf course, and much of it has people living on the boundaries of it. And so, for example, my restrictive covenant says that I can't have more than 3 trees on the property. I can't have a garden. I can't have a storage unit. I can't have trailers, and. So there are like 6 pages of restrictive covenants that are on the deeds, or go with the deeds to everybody who lives on the golf course. So you're on notice of this, of course, when you purchase the property, what the restrictions are for its use. You all should be familiar with zoning. You know, zoning. What is zoning? What is a zoning variance? So public land use comes with requirements. Clearly, you might not want to have a gas station built next to your home. Just some years ago, we had a company called Hyperion that wanted to build an oil refinery plant in our area. The first one built in the United States since 1976. We could understand that a lot of people in Vermilion and Elk Point and in the area weren't real excited about living next to an oil refinery. So we have land in the city and in the county that is zoned, that is restricted for only certain types of activity. For example, in the city, we have restrictions on residential zoning areas, on commercial, on agricultural, and so forth and so on. And so in multi-dwelling, what type of buildings can you erect on the property? Very common. A zoning variance is what's called an exception to a particular zoning rule, where a property owner wishes to deviate from a zoning ordinance and applies for an exception, usually from the city council or from the county board of supervisors. What they have to do is demonstrate that there's an undue hardship as a result of enforcing the ordinance, the zoning ordinance. They don't always get approved, but the classic case is when there is a new zoning ordinance, and usually they grandfather in everybody else who's already got property within the zoned area. What are non-conforming uses? Those are that exist after a new zoning restriction is enacted, and that usually involves those people who've been grandfathered in. But when the property has been resold, that may create some new issues. Let's talk about nuisances. What is a nuisance? Well, a professor, right? A professor might be considered a nuisance. Oh, come on now. Well, it's an unprivileged interference with a person's quiet enjoyment of his or her property. So, for example, having neighbors who are noisy can certainly create a nuisance, right? Neighbors who are constantly burning leaves or other types of garbage and whatnot may be creating an interference with your use of the property. What is a license? We've already alluded to that earlier. It is the right to use another's land for a specific purpose. It is a personal privilege and can be revoked at any time. I love this French term. What is a profit pendrait? A profit pendrait is the right to remove something from another's real property, like a crop, fruit, fish, hunting, and may certainly have been granted over a period of time. Profit pendrait, that they may remove something from the property. Usually hunting and fishing involves profit pendrets. What's eminent domain? It is the government acquiring private property for public purposes. So clearly, if they're going to enlarge the golf course and decide to take more of my land from me for the golf course, they would have to go through an eminent domain situation because the golf course is owned by the city. So what's a lease? What is a lease, boys and girls? It is a non-freehold estate in property. It's a right to possess, but not legal title over property. So let's talk about the types of leases, many of which I'm sure you all have. Certainly a tenancy for years, an agreement for a specific number of years, the length of the lease, 1 year, 2 years. A periodic tenancy that simply lists lease payment due dates that are specified, but there is no expiration of the lease contained in the contract. Tenancy at will, where a lease can be terminated by either party at any time. State landlord-tenant laws usually require at least 30 days notice before you can request a tenant vacate upon termination of the tenancy at will status. Tenancy at sufferance. This is when a tenant regains possession after expiration of a lease without the owner's consent. We sometimes simply refer to it as adverse possession. The Elwell versus Minor case is a case of that situation where we have a problem of the tenant and the landlord. The tenant was accused of non-payment of rent. The problem was the landlord kept increasing the rent each year for several years, but the tenant didn't agree to it. And so eventually, after several years, the landlord sought to terminate and evict the tenant. The rule is non-payment of rent is not a proper ground for the eviction of a tenant at sufferance, because the tenant is not required to pay rent, but only use and occupancy. So in other words, what should have happened here is the landlord should have sued immediately the first year for eviction because the tenant didn't pay the new rent. But letting it go several years without doing so created this tenancy at sufferance situation. Landlord's duties. Now, as I mentioned earlier, landlords have legal duties to They have obligations to care for property. Certainly, you might expect that when you enter into a lease contract, the landlord has the legal obligation to deliver exclusive possession of the property to you, not to interfere with the tenant's right and use enjoyment. So a landlord showing up unannounced wanting to inspect the property would be an interference with a tenant's right to quiet enjoyment. Certainly, the landlord has the obligation to maintain the lease premises in accordance with county and city codes. There is a legal requirement, the implied warranty of inhabitability. So if the property is inhabitable, let's say, for example, the heating goes off and the landlord refuses to repair it, we would agree that the implied warranty of habitability has been violated, and because the property has now become inhabitable. You can't inhabit the apartment during the wintertime without heat. So what can a tenant do? A tenant can legally withhold rent by the amount of the defective value of the premises. So clearly, if you decide to stay in it, you're going to reduce the rent. That probably will get the landlord's attention. You can certainly repair and deduct repair costs from the rent, or cancel the lease if the defect continues, what we call constructive eviction, or sue for damages. What is the right to quiet enjoyment? I mentioned earlier, quiet enjoyment is the right to have quiet pervade the premises. So if an apartment house has a noisy inhabitant, it's the landlord's responsibility to do something about that. Otherwise, that would be a violation of the duty of habitability and the right to quiet enjoyment. I always recommend calling the police too, establishing a record, and then usually, the police will take those calls and make official records, and in some cases even issue tickets for disturbing the peace. What is constructive eviction? Well, it's where the landlord interferes with the tenant's use and enjoyment of the premises so that the tenant must actually vacate the premises. An example, as I mentioned earlier, would be the loss of heating, right? Or the loss of power, loss of water, because landlords have an obligation to keep those in good shape, right? What is the implied warranty of habitability? And that certainly is a requirement that the building meet all county, city codes. Security deposits by law are supposed to be returned within 30 days unless there are deductions for damages and things of that nature. What are tenants' duties? Well, tenants have an obligation not to lease or sublease the premises for illegal or non-stipulated purposes. They can't waste the property, that is putting fists through walls. I think we could agree wastes property, and they're going to be liable for that. And at a minimum, your security deposit is going to be affected by that. Wear and tear is not included in wasting property, and clearly all property goes through wear and tear, and that's the landlord's responsibility to maintain. And certainly, as I mentioned earlier, a legal duty not to disturb other tenants and to pay the rent on time. What about assigning leases? So here in Vermilion, we have lots of students who are renting property, but they're only here 9 months of the year. What about the other 3 months of the year? Well, unless the landlord lease prohibits it, the tenant can sublease the property to another party. But if the lease itself prohibits that, then of course you can't do that. But if it's silent on the issue, then it's permitted. What about injuries that occur on the premises? It is the landlord who is responsible for foreseeable harm. All right, we have a case there where we've got Lindsay and her daughter living in this property. And there's this nutcase who is living with another girl in another apartment. And eventually this nutcase, who isn't even on the lease originally, ends up raping this other party. And the whole question becomes, because there have been numerous complaints to the landlord, was the landlord responsible for the personal injuries of the tenant? And the answer here was, hey, there was enough evidence for this to go to trial and let the jury decide that. But that if you could show the landlord was aware of the danger but took no action to protect the tenant, hey, there's a legal obligation there, certainly, to protect your tenants. And if you have problems as a landlord, you should call the police. That's what they're there for. All right, this brings us to a bailment. So what is a bailment? Another great old English term. What's a bailment? It is the rightful possession of goods by someone who is not the owner. So let's take, for example, every time we take our cars in for repair, we bail our car to the auto repair shop, right? We take coats and we check them at coat checks in restaurants, right? We take cleaning to cleaners. Well, they become the bailees, the parties who lawfully can possess those items but do not own them. Now, what's their liability? As long as they have control over the items. So, for example, you take your car in to be repaired, but some nutcase comes along and throws a brick through it while it is in the bailment custody of the repair shop. It's their responsibility. It is indeed. Same thing for any property that you've got that's being cleaned and is damaged. We would consider that the responsibility of the bailee to properly care for it, and a violation of that duty, and it would be the bailee who is responsible for the damages. What's a constructive bailment? Well, we all have found property belonging to another, right? And so we have constructive bailment. That is constructive control over that property. We know who it belongs to. And so we are holding it for the true owner's pickup, right, or return. And so as long as you possess it, you have a legal duty to care for it, okay? And so this Seppel versus the Republic of Hungary case is an interesting, and there have been a number of these cases involving property, Jewish property stolen by the Nazis during World War II, and this is another one of those cases. And so you have governments and museums and other parties that have gotten their hands on this stolen property, and the question becomes, who's the true and proper owner? And in most of those cases, the law has been that these bailees cared for that property on behalf of the true owners, and when the true owners, the heirs, finally are identified, then they have to turn the property back over to the true owners. And that the museums and other parties were merely custodians, if you will, bailees of the property until the lawful owners became known. So these are the legal duties of a bailee. Certainly the legal duty to return property upon demand. And then, of course, the negligence standard. To care for property as a normal person in that trade would actually care for it. So we would expect certainly car repair shops, cleaning shops, things of that nature to properly care for our property. What about an exculpatory clause? What is an exculpatory clause? You've seen them before. So, for example, a cleaners. You bring your goods in to be cleaned, and there's a sign that says, not responsible for clothing left after 30 days. Same thing at repair stations for automobiles, saying not responsible for vehicles left after 48 hours. Those are legal exculpatory clauses. As long as they are reasonable under the circumstances, they are enforceable. So that puts the property owner, the bailor, on notice that they need to come pick up their property in a timely manner. And that's what the Tannenbaum versus New York dry cleaning case is about. It's a simple case involving that, but the exculpatory clause on the ticket was hard to read and was not pointed out by the cleaners. How about errant baseballs at baseball games? How does a ballpark limit or disclaim liability? Or horseback riding stables, how do they limit liability? And so there are signs posted, and always on tickets to baseball parks and hockey rinks, there's always a disclaimer or a phrase of some type exculping liability under the circumstances and putting the purchaser on notice of, they're assuming their own liability. What about contract carriers? Well, there isn't strict liability, but you have to demonstrate that due care was exercised under the circumstances. But again, if you can show negligence, then there may be liability. And I think that's what's the GNLC Corporation versus Powers case poses here, that the gambler paid no attention to the exculpatory signs and notices that the hotel had and that the state of New Jersey had in terms of the innkeeper statute that placed the responsibility on the guest to store their winnings or their valuables with the hotel safe. It was reasonable under the circumstances that they should do that, and when some thief stole this person's property, too bad, so sad, dear dad. Well, look, I know we've covered a lot involving real property, but this is an important commercial law subject that I hope you have found educational interest and value in. As always, shoot, move, communicate. You've got any needs, I want to hear about them. I'm here for you. Looking forward to seeing you next week. Bye-bye, all.